Good morning, everybody. Uma Ismail, Regional Director, ASSOCHAM. Welcome you all for the Southern Region webinar on recent decision of Supreme Court tribunals and appellate tribunals and pre-packaged insolvency resolution process under IBC for MSME. So we see quite a lot of decision recently rendered by Supreme Court of India in the field of corporate insolvency resolution process, falling under the Insolvency Bankruptcy Code 2016, which reinforces the intention of the legislature in finding quicker, natural, and transparent solution of corporate insolvency. So these decision requires in-depth analysis. As such, they touch upon several important proposition and governance aspect. So to deliberate on this, today we have this webinar plan. Take the pleasure in welcoming all the dignitaries for the day. It's my pleasure to welcome the Chief Justice, Shri M.M. Kumar, Founder, President, NCLT. Welcome, sir. Welcome for the webinar. I also take the pleasure in welcoming Mr. Ritesh Kavadia, who is the Executive Director, IBBI, who will be doing the keynote address today. So welcome you, sir. Thank you for your time. And I also welcome Anilji. We are also been working with him for our program. Sir, thank you. Thank you once again. And I think it's been a long time that we got connected. We welcome you for this program and thank you for your support also.
The contribution to the GDP by the MSME is one reason why the entire country is focused on MSME, giving opportunity for a large number of employment generation in this country. And we have found India is one of the countries where 28% unemployment is happening today. And recent Economic Times report, there was a news item, I can say, which was based on probably some survey. MSMEs are likely to shut shops, close and all. So with the kind of expertise Anil Goyal has in the ground as a resolution professional, having done so many insolvency resolution, I would like to, prick his mind and understand what he feels. Is IBC a boon or bane for MSME? I'm not talking about the era that we are going to see after the pre-packaged insolvency. Generally, I am asking whether MSMEs are benefited or they are targeted. What do they really see? How do they feel about this IBC? Do you think IBC is a very welcome move for them, or how do you see? Can I have your views, Ms. Ranil Goyal?
Justice M.M. Kumar, my greetings to Mr. Ritesh Kavadia, my fellow speakers, panelists. The question is very, very important at this particular time when this country's employment more or less is depending upon MSME. IBC in the past, in the last 4.5 years, has actually not been done much for the MSME, but I should not say the MSME has not gained. In case you really understand, in their capacity as operational creditors, they have taken the advantage of IBC to a great extent. Mere the fear of, just the fear of IBC, a lot of large corporates have started making payment to their suppliers, who are mostly MSMEs. The OEMs have started making payments to their component suppliers. So they have actually gained out of the IBC in their capacity as operational creditors. However, the CIRP, which is coercive in nature, which is taking away their control and custody of the assets and business, which is disruptive of the running business as a going concern, which is also a stigma for MSME. That is now being corrected by introduction of pre-packaged insolvency resolution process. In short, we call it PIRP. See, the government in fact started working for about a year now, when on 1st of June 2020, the threshold limit for MSME was increased, and it is now very comfortable with 50 crores of investment in plant and machinery, and that too at return on value, and 250 crores of domestic turnover, and all export turnover is excluded, and the process of registration is very simple in Udayan registration portal. By saying so, the PIRP has been introduced in a lightning manner. 4th April, 9th April, everything was done. Regulations and the rules were notified, and presently it is all live, and anyone can approach the financial creditors to opt for PIRP. PIRP is where the most of the board of directors will continue to run the business. It is not at all coercive. There will not be any resistance. It is not disruptive of the business. There is no stigma, and it will be just considered as a restructuring proposal which is going on with the financial creditors. The courts would not take much time because it will not be contested. It is consensual by the financial creditors and by the corporate debtor. The benefit is now the IBC. Now the benefit is that there are many MSME businesses in India where the EBITDA is positive, business model is viable, feasible, but they somehow have landed into some kind of non-compliances, or they have over-leveraged themselves. They are not able to service the debt. So all these things actually has been a deterrent for any investor to come and invest in the MSME, for any person to become partner, for any person to acquire a running business, just because of the fear of uncertainties, which might even land, as the advocate Shri Ramji is saying, the Hydra head popping up, and that's something which is happening when someone takes over an MSME, and every day you get some notice or some claim. So those Hydra head would not be popping up in case the takeovers, mergers, amalgamations, one-time settlement, restructuring, all if it is done through the framework of PIRP, that actually would be a real boon for MSME under this new structure, which is PIRP. This PIRP structure, to my understanding, is the best introduction for MSME. Even if this PIRP fails, the MSME corporate debtor will not go to liquidation. It will continue with the board of directors. It will run the way it was running. And in case the PIRP is not acceptable to the financial creditors, the corporate debtor, the board of directors may think of other options, maybe selling of some of the assets and approach for OTS again. So every 90 days, they can again pass a declaration, they can again pass a resolution in the shareholders meeting, and their 90 days would start again. If the first proposal, if the first base resolution plan is not acceptable by the financial creditors, they can even reach out to the financial creditors again within the first 90 days. Because see, the three-year period, which is considered to be a cooling down period after one PIRP fails, that is only in case NCLT passes an order and for commencement of PIRP. Whereas the pre-PIRP period of 90 days, this can be started 10 times. If the financial creditors are not accepting my base resolution plan, I can again reach out to them with the second base of a resolution plan, which can be better, which can be with some partner, which can be with some sale of assets. So to my understanding, this PIRP is definitely a boon for MSME, for investment, for adding partners, for adding shareholders. This probably is the best, and it's a boon. Thank you.
Thank you, Mr. Anil Goyal. I would like to now request Sri Ritesh Kovdia on a very interesting question which has come to my mind. Why we have not thought about pre-packaged insolvency process for all the corporates, particularly because I have a view that if one large corporate is saved, several small corporate can be saved. And in the entire process, what happens is, somebody was telling me on a lighter side, the Ministry of Finance alone is getting benefited. All other ministries are suffering haircut. I mean, banking, financial sector is getting all the proceeds, whereas all the operational creditors are suffering whole washout. So if one large corporate is saved through a proper pre-packaged resolution process, thousands of ancillary and small undertakings could be saved. Their monies could be, protected. So therefore, I just wanted to see what was the logic behind to introduce only for MSME and leave out the large ones, which are probably, in my opinion, in the economic system more important. May I have your views, sir?
Yeah, just as I told, this pre-pack was already in the offing, and when this pre-pack was recommended by the committee, it was recommended for all the corporate debtor, but in a phased manner. And before it could be implemented, this COVID pandemic arrived on scene, and a resolution framework for MSMEs were very much required. These MSMEs are somewhat in between corporate and individual sort of structures. Many of them rely on informal structures. Their family members are board of directors, or the residence itself can be the registered address. So they have some characters of individuals also. It's not there is a fine line between corporate and individuals. So some characters of individual insolvency are required to be for resolution of MSMEs. So because they have informal structure, so not many resolution applicants will be interested, and only the corporate debtor itself might be interested in taking over the assets after resolution. So considering all this, and as you told earlier, that MSMEs are under great distress, they urgently require some help. So this was a thought that let it be a phased implementation. At the first place, we can have pre-pack for MSMEs, which itself is a generous definition. It covers more than 55% of the companies registered as on date. So, and for the larger corporates, can be tried with CIRP. And even in CIRP, normal CIRP, a promoter, if it is compliant for with 29A, he is free to participate. So the only issue is of the management, who controls the management. Otherwise, any promoter, even in normal CRP, is eligible to participate. And the 29A restriction is very much there in PPAC also. So this, but pre-pack is a cost-effective process. But we believe that larger corporates can bear the cost of process for some time to go. And we hope that once this is success, this experiment is successful, we will get some variant of this scheme for other corporates as well.
Because it is not that in India we never had this. We had this debtor creditor arrangements, corporate debt restructuring, 391 schemes, and for several years we have been having the RBI mechanism of CDR. Therefore, it is not that something is new. It is a case where it is possible that immediately a prepackaged resolution process is brought, whereby the entire CARP process can be cut down. If the financial creditors ultimately the COC with 66% is only approving the resolution plans also. So the one difference will be elimination of undesirable promoters under section 29A in the CARP. In a PARP, the same promoters will present a scheme. Probably that is the only aspect I think we will consider this, we will discuss about it. Now I would like to just see whether the general talk in the field is, they say the number of benches is insufficient, the number has to be improved. What do you see about it? I may have the views of everyone here because it seems to be a very fundamental question. In an efficient system, there should not be lag. And if number of benches is less, and if they are not situated across the country, and opening up for MSME, opening up of personal guarantors, conferring jurisdiction on the NCLT for personal guarantors, this requires, in my opinion, more wider presence of the benches and more number of benches, more number of people in that. So I would like to start with the senior advocate Srinivasan Ramji to say whether what is this actually? Is it really there? How does he feel about it? What are the suggestions or what are the ways of taking care of this situation? May I have your views, sir? I would like to ask everyone, of course, on this topic.
Thank you very much. I think, yes, it's an extremely important issue that you have raised. Every institution is only as good as one, its leader, and two, the people who man those institutions. Now, apart from the quality in selection and manning, and therefore leadership and implementation, if you don't have people to man those at all, then it is bound to fail. And slowly you will find that the graph, the speed, and all of that we had spoken about earlier is bound to slow down. So therefore, you need to have people, I'm told, and you had forwarded that order also of the Supreme Court recently, where the bar had gone. And they said there are only 38 members available out of a sanction consent of 63 in the NCLTs. We face this problem every day. When we are arguing, the benches are not available. There are two benches of, say, Jaipur and Chandigarh, two members who are now holding together because there is no judicial member. Under Madras Bar Association and under our Companies Act also, it says very clearly that a judicial member has to be there. And then if there is no judicial member, then how can you decide? So therefore, if a judicial member has retired or is not appointed or has demitted office, then fortunately, because of video conferencing, therefore another member is available. Otherwise, that bench wouldn't have. And apart from this huge slew of matters that were filed, there is a slowdown now because of COVID, all right, and urgent matters are not taken up. But that floodgates are going to open up. That mountain of matters which has not been decided are going to weigh down upon the NCLT and NCLAT, who has been without a chairperson, a full-time chairperson for now since March of last year. And one acting chairperson has retired and the other one is holding fort and he will also retire soon. So where are the members? The acting chairperson of NCLT is bound to retire now in the next few days. 31st, that is tomorrow, the day after tomorrow. So therefore, he's been continuing. So therefore, there is no clarity. I think it is very important that we have to have institutions, and those institutions must be manned. There is a problem. There is a practical problem also which is being faced, and this is ailing not just the NCLT and NCLAT, but also all other institutions. The High Court has vacancies all over. The Supreme Court has got vacancies also all over. So I think apart from the fact that it is difficult to find talent and trained people, therefore those are the two primary things. Even if you wanted to, there are some delays that are occurring. So whatever it be, the action must be taken in a transparent fashion for the best future of the implementation of the Act. If the Parliament has created it, then it must also make sure that the executive implements that and gets them on board very quickly. Otherwise, there is bound to be a slowdown. The sufferers will be those very people and the economy ultimately in a legislation like this. So it is not just one or the other person, but it will be the economy. I agree with you completely that this is an extremely important.
Thank you, sir. In fact, this is our country. We have seen recently SEBI has filed an application saying that the technical member of the SAT is not there, therefore the bench is not properly co-rated. And we had the IPAB with Justice Manmohan Singh alone not able to sit because the regulation said 2 members are necessary. In fact, I appeared before him once. It was all matters getting adjourned only. So I think, as you rightly,
the short-term answer has been then to do away with IPAB. Then they have gone ahead and done the and then AIRAT, for example, Airport Appellate Authority, they've said no, let it go to the High Court. But the High Court is already burdened. There are dates that you get are 3 months or 6 months later. Here, at least in tribunals, it was faster. So therefore, whether the quality may have not been to that level, but at least 50%, 60% of the cases were being decided faster and quicker for the institution. This is true of telecom. There is no member, there are 3-member benches. The chairperson there is acting only on the orders of the Supreme Court at the moment, his extension. In Electricity Act, there is no member that is available. They are sitting with the musical chairs, benches available, not being available for board, etc. So therefore, and they are going to retire. The chairperson is now going to retire in August. There is no visibility of who is going to be the next. And likewise, you've seen all in the other tribunals also similarly. I think that has to be addressed by the government.
I have the views of Sri N.K. Dilip.
So I think Yeah, I think the only thing that I can add is that with technology that has enabled and with the video conferencing is there, that we hope at least with the resources that we have, that we get more efficiency is what so that we can break it up, like just date matters, hear it online, hear it on a specified day, do a hearings on particular date, fix times for hearings so that they're never uh, drawn out, so that we get some efficiency. I hopefully we will use this crisis to get an opportunity.
I'm sitting in US. I was told here when I was inquiring, there is no retirement age for judges. And I
Yeah.
found on the streets when I go for walking in the morning, there are a lot of places where boards are kept, elect so and so judge. Therefore, I think the lawyers forum or somebody is electing the judges also here, and there is no retirement. If there are good judges, why would you unnecessarily retire? Of course, administrative purposes, somebody can be senior, somebody can be taking care as this chief or presiding officer or president, chairperson, whatever name you call. So we have good judges, and they are all running beautifully arbitration tribunals, and they render excellent decisions. Of course, may not come in the public forum unless Section 34 or something comes. So I feel that in spite of India's population, we find less number of members and judges. So we may have extension of tenure without any retirement or whatever it is also, unless there is some other reason why he should not be considered as a fit person for continuing. May I have the views of others, like Mr. Anil Goyal. Do you have any thoughts to share here? Of course, the fundamental is that number is less. We need more benches, more people.
See, I only would like to add that gradually I have seen the financial creditors or operational creditors, they have stopped invoking IBC or even DRT because of the lack of efficiency over there. Because in IBC, we actually find that even some of the applications are very, very urgent for decisions, otherwise it might impact the entire process. But those are also not being taken up. Even if we are asking for a 1 month extension of the CIRP, and that application is being heard after 4 months of our actual application, when we are only asking for 1 month. So this actually would, as Senior Advocate Ramji says, this will actually impact the entire hard work which has been done by all the ecosystem stakeholders, all the hard work done by IBPI and most of the stable ecosystem that we have seen in the first 2 years, that even might get adversely impacted. Very, very important that we have to do this.
I may only add one more thing. What Mr. Goyal says is right. Increasingly, in my experience, I have seen now increasing number of resolution applicants who want to withdraw.
Yeah.
This is a very serious matter. People who came in hoping that they will invest, you see, ultimately we have land, labor, capital. And land is fixed. Labor can be obtained. Capital is fluid. It will go ahead like water and find the level which suits it the best. So if you are going to delay and capital, somebody wants to bring in capital to revive a company and you're going to take 1 year, 2 year, 3 years to approve it, that capital will now go ahead and other lenders are waiting. They will go to Singapore, they will go to Brazil, they will go to Russia, they will go somewhere else. So you will never find. So therefore, then to go and say, no, I will not allow you to withdraw. I will not allow you to withdraw. And therefore, I will impose a penalty and encash a bank guarantee and start proceedings against you is actually like an ostrich. You're putting your head buried in sand, not realizing that this is a fact of life. And therefore, there has to be some urgency in matters like this. It is not enough to simply say COC has to decide within 180 days and then so and so. And then there is actually, thereafter, we can carry on till the cows come home. These days, cows don't even come home.
Maybe Justice A.K. Sikri had some foresight. He said everything directly. May I have the views of Sri Ritesh Kaudia on this? Of course, a regulator, he may have better
Yeah,
infrastructure study, and he is also an
no.
economist.
Basically, there is no denying the fact that present capacity crisis is there. Government, for its part, had initiated the process, and we hope that it will be completed soon, and we soon have a capacity augmentation. Government at its highest level is alive to the fact. Even in this budget speech, there was a mention of improving other aspects of NCLT administration, food system, etc. So government is working on that. This aspect is well within. Government is working on it. I can only say. I have to present government because of the most proximity to government among the panelists.
You must be aware, they must be doing. In fact, the affidavit they said is that because of the
They are doing
larger issues of number, age, terms of service issue, they have not been able to bring people. I think that is the latest statement I have seen in the recorded now.
And even apart from that, some work is going on for further consideration, but all this is part of government policy.
Yeah. Right. Mr. Dilip, you want to say anything?
I'm just adding in Rivier, I mean, diverting to the situation of the PIRP. So this is, I mean, just getting back saying this is I mean, look at PIRP has two benefits. One is the promoter knows the business the best. Second is, as Mr. Anil Goyal pointed out, that you are able to do a discussion before you land into the CIRP, and there is that creditor in possession situation. So the MSME, so I think we have to, as professionals and as people, encourage PIRP to come forward and move forward, because ultimately that's the only which way that the industry goes forward. So, having while we like to have a judicial discipline and judicial oversight of it, that's all tested. But ultimately, if the business has to go forward, the creditor and the borrower has to come to an understanding. And I think this structure would, if encouraged and implemented quickly, will give the impetus to move forward, because they have tried to make a very good balance between creditors oversight with debtor in possession during this period, compulsion of timelines 90 days, if the base resolution plan is approved and goes through without a haircut to the operational creditor, you would be out of you'd be out of the news as quickly as possible. So, I mean, I think the key issue that, as most of us have commented, that there is discipline in the creditors, it has to come out that the PIRP should be done at the earliest stage. We have this habit in India that because of personal guarantee, we will extend it, I'll extend it. Hopefully, some miracle will happen. So, I mean, we have to get into economic discipline, and hopefully this is a good beginning in my view, because it's the knowledge of the industry is with the promoter, and so if he is encouraged to resolve it, it will be the best option.
So, Mr. Dilip, I would also like to add, like this actually would lead to not much of pressure on the benches, because hardly there will be any contest regarding the claims or regarding the corporate debtor contesting, or even the financial creditors are contesting, because everything is settled much before. There is no scope of non-cooperation, because if there is a non-cooperation, then the financial creditors will not even agree at a preliminary stage for even give a go-ahead for PIRP. Most of the information will be updated. The financial creditors will rule, as in case the information is not updated, the PIRP would not start. The financial creditors are even thinking that they would say that before we give you go-ahead in principle to start PIRP, we would even ask for the forensic audit or transaction audit, so that we know it beforehand whether the act of the corporate debtor, the promoters, board of directors had been kind of questionable, or it is all clean and it is a natural business disaster. So with all these things, less litigation cost, less litigation-led cost, no coercion and no disruption, I think this also can be extended to partnership firms and proprietorship firms. I think Mr. Ritesh Kavadia can also give some kind of inside information, whether it is being thought about, that if the partnerships and the proprietorship business can be brought into PIRP before all partnerships and before all proprietorships can be considered under CIRP.
Yeah, basically 95% of the MSMEs are under proprietorship firm or partnership firms. So their requirement is very much urgent. That point is well taken, and the government is has this is under policy consideration, but as such, neither much concrete is known or I am competent to comment on that. But of course, this was under deliberation. Some capacity issues have to be sorted out before rolling out any further reforms, because as such, their educating authority for them is DRT, and DRT structure is already overburdened.
Do you remember we had a session in IBBA itself in the presence of MS Sahu, and all the DRT officers were also present. We have discussed about this issue of, for example, if you take the entire South, DRAT is functioning only in Chennai. And the moment you go there, there may be posting of one appeal. The next date will be another 6 months for whole of the South. The capacity constraint is definitely an important subject. But I would like to now just move to another important topic because the time is running out, and I would like to see at least two or three questions. We take the views of best of the views of the panel here, eminent panel here. I'd like to just ask Mr. Srinivas and Ramji on this particular issue. I've always been carrying this thought that now the SARFASI is there, DRT is there, people are filing OA, people are filing SARFASI actions, Section 17 appeals are made. So proceedings happen for years. And thereafter, we say that it is all excludable, these are all extendable. Now you can file IBC, this thing is continuation despite the purpose being different. I used to remember in old days we used to listen to a jingle called "First to Bata, then to School." Means children have to wear a shoe or something and then go to the school. Similarly, I always think first to IBC, then to other forums. So may I have the views of Sri Srinivas and Ramji, because if you spend 2, 3 years, 5 years in DRT, and in some cases we have seen several years have gone, all these look back period and all would have gone. Whatever they wanted to do, they would have done it. If it is Article 137 and only 3 years, there would have been at least some sort of mechanism to cut down the period within which you approach a resolution, system, because it has coordination of so many other important things like avoidance transactions, look back period, and all. So I just wanted to just see if Sri Srinivas and Ramji's views.
Right. Yes, I think it's an important point, but I think this is sort of a twofold answer to it. One, that most of these actions that you mentioned about SARFASI and other proceedings in civil courts, etc., are historical legacy issues. So people went there before December 16, and thereafter, a lot of people have taken this decision in the last year or 2 or 3 years, seeing the success of IBC to proceed. There are certain issues. One, that a bank or a banker or a financial institution may want to recover its money on the basis or a strength of a security that it has. So therefore, it proceeds to those recovery forum or fora. Whereas IBC is not. So therefore, it knows that if I were to go to IBC, I may not recover on the strength of that security, because that security will now have to be put in the pool, and therefore somebody else may come. There is bound to be a headache. So the degree of his cost benefit analysis that he does, waiting for some more time, having a short case, and going ahead in DRT or DRAT is one thing for recovery of my money. On the other hand, going to IBC under Section 7 or whatever else, and then not having the security of that security or the charge or whatever else, and therefore putting it in the pool and maybe. So that benefit analysis being undertaken, I find, however, that more people, even though on paper we all say, no, IBC is not a recovery mechanism. Actually, it is turning out to be, people are hoping that the moment I go ahead and do this, somebody will come and settle with me. And therefore, smaller amounts are settled, and Section 8, Section 9s are only on that basis only. So we can say on paper that they are not recovery, but really speaking, they are. They're an attempt to get monies out as quickly as possible or settle. So I think this, therefore, and in any case, Supreme Court in Jignesh Shah has said now The fact that you have filed a winding up petition is not a ground for you, or a suit that you have filed earlier is not a ground for you to extend limitation for winding up. Likewise, the fact that you have filed a SARFAESI by itself or a recovery action by itself will not extend the limitation for filing IBC. So therefore, if that was done on the basis of a trigger within 3 years, that trigger cannot be used to come in the absence of an acknowledgement to file an IBC. So my view is that IBC should be popular. It is a method, a tool to get people to pay up. And sometimes now people are backing out of consent terms also. That's another disturbing factor.
Correct. May I have the quick view of Mr. Dilip?
I think you know as Mr. Namji said very clearly, you know, anything is possible. We hopefully we will get more judicial discipline. I mean, let's also look at the other situation that we are seeing situations that CIRP fails, liquidation started, and then we see a backdoor 230. In 230 there is a compromise coming under the Companies Act. So you know, I mean, we see everything that is happening as a possibility. We saw the recent Sivasankaran case, the withdrawal of you know, one-time settlement being offered, DHFL's case. So I mean, these are. I mean, we leave it as outliers, and hopefully we have to look at the 80-20 rule and look at the main provisions for success, and not get distracted by, you know, the side shows that may happen.
I'd like to ask yet another important question on this commercial wisdom and COC. Role of adjudicating authority is very, very minimum. I'm not talking about PARP, I'm talking about CARP itself. We are not finding any role at all, almost like, you know, just look tick boxes type of thing. Commercial wisdom, but there are possibilities. There must be some visibility to others. There is no publication of even salient features of the resolution plan before it reaches to the adjudicating authority. Parallelly, if you cut across and just go to Companies Act, you will find there are at least 4 times in 2 newspapers of language, local as well as national. There must be visibility at the application stage, at the petition stage, and yet even after the meetings of creditors, class of creditors, you have a objection right, a right by way of a creditor or a shareholder with a particular threshold of 5% and 10%, directly approaching the NCLT and doing objections they can file. So when that sort of a restructuring or an amalgamation merger in an ordinary non-insolvent status itself is allowed, why not in insolvent status? There is something done to publish at least salient features of the resolution plan, keep a window open for at least material irregularities and frauds, like the Regulation 16 DRT cases. So why we should not have a small mechanism where there is some sort of a window available for operational creditors, for promoters, for others to come and say something about it. There are cases where we have recently heard about certain collusive things and all orders have been passed banning somebody from entering the scene. So may I have your thoughts, sir? Srinivasan Ramji, please.
Yes. Well, I think I always believe in that age-old fundamental basis, which is transparency in all actions, especially public actions, is extremely important. And sunlight is the best disinfectant. So therefore, if you open and be transparent, you don't have to be transparent in the sense that you go ahead with a 200-page, 500-page resolution plan to be published, etc. But a salient feature of a resolution plan, all the same way that you have to have public notice and the RP has to publish it when there is an order that is passed of CIRP. The same way upon conclusion also, I think that it is important that the conclusion has happened and this is a salient feature must be published, because people otherwise don't have an option or opportunity to examine or know what has really transpired in the matter. But having said that, this should not be a ground for mounting challenges. Therefore, the principle being that, look, there was an existing management which has driven the company to the ground when they were managing it. The 2 largest stakeholders there were, one, the equity brought in by the person who is driving the company, the promoter, and he borrows And therefore, whether it's a debt equity ratio 70, 20, 30, 40, whatever else it is, that the equity, the exposure of financial institutions is large. They are together and they're supposed to be together in having managed this company throughout with minimal interference from financial creditors and application only by equity shareholders. That's the capitals, two-part capital. If the one-part capital holder, namely equity, has driven the company to the ground, the other man steps in. And therefore, he takes control of the assets because his stake is an exposure is the largest, on paper at least. Therefore, he then constitutes and he says, I have to have a change in management because you have proved to be inefficient and incompetent. And you're risking all our lives, and my monies are public monies. Therefore, he's a custodian. He's representative in character. Therefore, there is really no need for large number of people to come into COC to decide. That's what the Supreme Court says. Therefore, the commercial wisdom, one commercial wisdom of a promoter who has failed, the commercial wisdom now of the financial creditor, who is now also an expert in that field. He's got those people, he's got his ear to the ground, he's lent capital also, must take steps to salvage the matter. There is really no need for anybody else. But a salient feature of a resolution plan as approved can be published, should be published. It will add only to, it should not lead to opening the doors to large number of litigation because that is delaying matters. Now, I want to say I have two caveats to this. This is very important from a practical perspective. And I'll tell you what happens in court. One, most of these matters, the dirty dozen, etc., were historical, as you said, and Justice Kumar also mentioned about evergreening, etc. The lenders were lax. RBI now came down heavily on them and said expose, provisioning, NPA, declaration, etc. was a measure to go ahead and put some financial discipline onto financial creditors who didn't care because they were dealing with public money, is your and my money only. So therefore, there had to be some accountability. Expose yourself. If you were to declare NPA, people and the RBI and the others would know, why is your NPA level so high, you banker? So that would be a question. So therefore, banks scramble to try and avoid as much as they can. But now they're all exposed. They have to be. So therefore, bad banks, big banks, mergers, etc., all of those things, capital protection. Therefore, financial institutions and capital FCs must and be held accountable because they are as much, and in their loan agreements, they have as much level of participation and monitoring. And not later to say that what happened, why this happened and all that stuff, and therefore whether we should go. So they are equally responsible. They have a stake and they have to have, they owe it to the public, to therefore, because it's their money. One, therefore they should be held responsible. Number two, which is that after having done this exercise, they are now acting in representative capacity. So therefore, they must go ahead and find the best optimum resolution. Supreme Court therefore trusts them in their commercial wisdom to do it, and no interference is called for. Therefore, minimal judicial interference except a procedure that is to be followed. In this, the role of the others really doesn't matter because if the company had gone down and they had been wound up earlier on one petition earlier itself, then the stakes of all the people who were involved would have also gone to the ground. There was no accountability. Nobody could come to salvage the company. Therefore, this is only a measure to get somebody else very quickly to come in with the largest stakeholder, namely the financial creditor, salvaging the company. It's in the interest of everybody else. So really speaking, participation by the others is not envisaged under this legislation, and rightly so. Otherwise, it would delay. With objections, so many objections that I'm dealing with. If a resolution, successful resolution applicant has come, he has filed, he's willing to bring in money, application filed, but the matter is pending in court, all sorts of applications. Everybody, every OC that you know is filing applications and he has to deal with it. This is leading to another serious problem. The Delhi High Court has ruled that if an avoidance application is pending for some serious matter, if you have approved the resolution plan, then all the resolution avoidance applications drop to the ground. Go away.
Gone. Yeah.
Venus, and I'm challenging that. I have challenged that in the division bench, and they are supposed to hear.
The HR agency case.
That's right, the Venus Textiles and the Venus matter, that one. So that one is gone. Fortunately, however, there is a hint in the Supreme Court recent decision in Alok, where they say that no, the Supreme Court, the NCLT is not functus officio in a matter relating to under 60 subsection 5, all matters relating to or incidental to. So therefore, that should be an answer to that issue in any case. So that you can't render it infructuous.
Thank you. I have your views, Mr. Ritesh Kodia. Do you think there is a reason why we should not publish the salient features of the resolution plan before it goes to the adjudicating authority sanctions it?
Yeah, basically timeline is the essence, and we put every endeavor that it is resolved in time. The law takes care that no stakeholders is worse off than the liquidation, and independent person, that is resolution professional, is there to ensure that as such this resolution plan at least ensures the statutory protection that has been given under section 30 to the operational creditor, to the dissenting financial creditors is given. And recently, in one of our amendments in the CRP regulations, we have provided that all the claimants, including operational creditors, will be provided the principles or formula of distribution of amount. Earlier, that was not required, but now under CRP regulation, that is required. Because after resolution plan is approved, the RP shall within 15 days intimate all the stakeholders. So at least this information gap issue has been taken care of, and if someone is so dissatisfied, the option with the appellate authority is always open. And if the operational creditor is a significant one, that find place in the COC meetings in any case. So we don't want to this opening of a Pandora's box or a further litigations on that. That is a thinking behind it. But
Correct.
Mr. Dilip, quickly, because time
I
is
mean,
very less. We have one more important question to go.
Sure. I think, sir, I mean, while you've clearly highlighted the concern, and we have experience because we act for a lot of private equity investors. The minority shareholder in this transaction, while you have a majority shareholder, promoter, 29A issue versus creditor, operational creditor, the minority shareholder who may have actually put in a lot of money but never in management, he's left high and dry in this whole resolution exercise. Unless he comes in as a bidder, puts in more money, so he's in a situation that he's put in money which is going to get wiped out. Now if he has to save himself, he has to put more money in. So we have experienced this for a lot of minority shareholders who don't have knowledge, who are in the wrong side. They have been as badly off as the creditor, if I may say so. So the shining light on the transparency will give them some benefit also. And because see, they all treated as equity, so they wipe out the whole equity, and so minority shareholder, he's lost his equity and he's not participated in the business also. So that there is a sense of unfairness there. We have also seen RPs sometimes deciding arbitrarily on the claims, so and that doesn't get pursued. So it is good order that if it gets published, that that because nobody follows the sequence of events. A claim is filed, then is the plan approved? Is it a new plan approved? When was the COC meeting happened? COC filed here. So it will be good order that if prior to a hearing is a public announcement is made, so that if there is been significant fraud or anything, we also can bring it to the notice of the adjudicating authorities.
Because most of the cases, even I have found state government authorities come and say, we never knew about it. It is lost for all. Suddenly there is a statement, CIRP has gone and the resolution plan is approved. It is binding on everybody. Section 31 has come into play. You have to go by that. Nothing else. It's closed. So moving to another important question, I would like to
add, Mr. Ravichandran, maybe it is necessary that we give notice to the state government like we do in a merger, right? Statutory authorities concerned, where we give notice to saying come RD or OL or any statutory authorities notice is given. Maybe which is a good idea that we impute that into the CIRP proceeding, so that those parties who are, because you are saying everything is wiped clean. So we should get the notice brought to them saying, boss, please come and file your claim, land, XYZ, anybody and everybody. So maybe it is a good idea.
That is being done. They have to use the RP will issue notice to all stakeholders, and therefore they have to file their claims. They're told about this public announcement of the IRPs.
But yeah, public announcement versus actual notice, I was just saying.
Even inviting, the RP writes to them to invite their claims, and so therefore statutory claims are invited so that he then verifies. I think most of them that happen.
So one last question, because the time is running out. We would like to hear from each one of the panelists. I have always felt, and the ground reality is also such, that operational creditors are having a very discriminatory. Uh, Normally in operational mismanagement cases, we used to say the minority shareholders filed the petition, the operation success patient died. So similarly here also, nothing happens. And once situation was when SR Steel and Flat Harish Salve was arguing. Thereafter, there was an order, some theory of equitable distribution, non-discriminatory, and all came. So I would like just to have the views of everyone here because we are talking about MSME with a thrust, and most of the operation creditors will be in the MSME sector. And that's why I was saying bring pre-package for large corporate. One large corporate saved will be 1,000 small companies saved or 1,000 small entities saved. So I just want to know, is operational creditors given a raw deal in this IBC structure? This is the winding up question. So I would like to request everyone to say 1 minute, one answer. Senior Advocate Srinivasan Ramji first.
Well, on the face of it, it does appear that there is discrimination. There could be a large operational creditor, although he has some presence in the COC also, above a certain threshold of 10%. But by and large, the Supreme Court has now ruled that they are not equally positioned in financial matters of management of an enterprise. They are very narrowly involved in a company's affairs. And therefore, they do not have the ability or the expertise to turn around or steer a company, which a financial creditor has in the business, the entire business of the company. So therefore, there is a legitimate and reasonable distinction between the two. They cannot be equated. So Article 14 really does not apply. I think that's the larger scheme, and that is how it functions. The amount of financial contribution and investment that FCs make in an enterprise is far more in one enterprise, percentage-wise, stake-wise, than an operational creditor. So therefore, that explains really the difference, except, of course, a home buyer, so which is a separate subject altogether. So I think we'll deal with that later.
Mr. Dilip?
I mean, this is it is a serious concern because while Mr. Srinivasan has rightly set out the scheme of the act, and we have no other option other than to be under the scheme because the Supreme Court has given its blessings. But it is a challenge. We have seen significant operational creditors getting the rough end of the stick in these transactions, and it only then comes into the situation of they deciding not to advance credit, or how do they go about it. So it is a tough position for them, and undisputedly. Thank you.
Mr. Ranil Goyal?
So to my understanding, the entire structure of IBC is based on the liquidation value due to each stakeholder. Now, if a company doesn't have assets and that company is being the company is having a lot of deficit in assets and liabilities, and the company is being projected as a zombie company and it is being carried away, then the most adversely hit class would be operational creditors, because this the corporate debtor, the board of directors, they would again and again reach out to the operational creditors, and they would not disclose their correct financial position, and the gullible operational creditors will extend more and more credit, and finally they would be totally losing their money when the company goes into winding up under the earlier Companies Act. Now situation under the IBC is that, first of all, that the default will be reported by anyone. So there is no such situation that the promoters are just carrying the default under the carpet and they are not disclosing it, or even the bankers are also keeping it under the carpet because of their own profitability and provisioning issues. Now, it is more protective to the operational creditor that they have to see the financial information, they have to work based on the financial capacity of a customer before supplying the material. The situation is not changed with the promulgation of IBC in the country. Earlier also it was the same. While this COC is having the commercial wisdom, they are also mandatorily has to cover in a resolution plan if there is any value due to operational creditor, that has to be provided for. If it is not provided for, the resolution plan is not supposed to be approved by the committee of creditors, neither it is supposed to be approved by the NCLT. So the operational creditors have not lost anything. they are rather in a better situation as compared to the earlier era, where the companies used to go for winding up after 20 years of continuing as a kind of a deficit, with the deficit in asset and liabilities. Now the situation is much better. They are more informed, they are more protected. They have now started doing their documentation much better. They have shifted from social structure of recovering of their money. They have shifted to formal structure of recovering their money. So that is to my advantage, is a benefit to operational creditors, and they are not left out. Just by participating into the committee of creditors would not make them entitled to any share in the assets of the company, because Section 53 is almost the same as it used to be earlier in the Companies Act 1956 or Companies Act 2013. Thank you.
Mr. Ritesh Kaudia.
Yeah. Right now, the cases coming under insolvency are cases which are badly delayed. So we see a large haircut even for the financial creditors. So as the things get stabilized, we can see early applications for resolutions where the haircuts will be less for financial creditors, and even operational creditors can get significant amounts. This by last one amendment, this operational creditors have been further strengthened, that even if the resolution value is more than liquidation value, the resolution value will be distributed in the order of waterfall. So we have to see the holistic picture in the, if we consider some 4,000 companies going through resolution, but we have to see thousands other applications where the operation creditors raise demand notices and their demands were fulfilled. These are the cases where the corporate debtor did not have money to fulfill the demands and it landed into insolvency. And it's a normal practice that rights of secure creditors, financial creditors are kept above this in the waterfall. That is a conscious policy decision, because if we do not do it, this availability of credit won't be there. If financial creditors are not given appropriate security, they won't lend to the debtors, or even if they do, they will increase the cost of credit. So these are deliberate policy choices, but operational creditors normally their dues are for a shorter period. Most of them have been beneficiary of this improved credit culture. So it will be difficult to say that they are left high and dry, but of course this waterfall has to be respected. But as we move along ahead, and insolvency triggers happen at an early stage, things will certainly improve. And we have to be mindful that the corporate debtor has to function after resolution, even during the CIRP process. It relies on the operational creditors for supply. So then it continues to satisfy their claims during CIRP process as a going concern. And there is, because their dues are not significant, so there is no reason to believe that they will be simply left high and dry in almost all the cases. So one SR case should not be taken as a precedent. Thank you.
Thank you very much, sir. And Justice M.M. Kumar was saying about various other laws and regulations, the Contract Act, Constitution, etc., to be studied. Similar lines, I wanted to just say a concluding remark that in order that the IBC functions effectively and efficiently, we have to have other regulators also supporting it in the same manner with the same efficiency, whether it is state government departments, whether it is central government departments, whether it is the regulators. There is a lot of difference. Everything will fall in line in IBC probably, but there are ancillary things. There are hundreds of things around there. The same reach is not there, same dynamism is not there, same efficiency is not there. So in order to build an ecosystem which functions and delivers its objective, my opinion is there must be always an all-around approach. Everyone must play its role faster than ever before if the IBC has to work wonders. So with this concluding remarks, I would like to give one opportunity to everyone to say one sentence and close the program. Srinivasan Ramji.
Well, I think with the start of IBC and its successful implementation, we must hope that there is greater corporate governance, which includes all, not just the equity promoters, but financial institutions who have been given this right must lay the lens of examination very, very clearly in every aspect. If they did that and they carry the onus as a representative of all the other stakeholders, they must ensure that the company never goes down and that monitoring happens. If that corporate and fiscal discipline is maintained, not just in the corporate, but in their books also, we will see an improvement all across all the stakeholders down the waterfall. So I think ultimately this must lead to that. This is only a tool to ensure that financial discipline and corporate governance is well maintained.
Thank you. Mr. Dilip.
Uh, I mean, I agree with you, what your comments made initially. I think the additional regulation, additional modification or things that need to come into place is that, we have now happily agreed that CIRP is very good. It's for the benefit of the creditor. Having personal guarantee for a corporate loan is something that we need to look at going forward, because you are saying that it is a creditor, it is a separate legal entity, all of those things of the notions that we have. But if you are, all of you have assessed the whole of the loan portfolio based on the personal guarantor of the promoter, and you are today saying the corporate debtor will take in the CD will the FC will take 50% from the CD, restructuring happen, then we will go to recover from the personal guarantor also. I think that it's time will come that we have to see how lending happens going forward more and more, because I think these two are inconsistent in a long-term basis. Because if you want the corporate to be restructured, then he should be ready to say, I myself will take it under 10 under to restructuring and ensure that the entity survives. But if he's got a personal risk other than his equity, even his personal assets which will come into play, there is no motivation for him to restructure it. So I think we'll have to do some incentives or restructuring in the lending matters to ensure that the entity survives and the personal is separated. Thank you.
Mr. Anil Goyal, quick concluding.
So I believe unless the capacity of the NCLT is not increased to a greater extent, no further arm of IBC should be promulgated, should be notified. And second, which is most important, is that in case the avoidance transactions applications are not attended to and not disposed of quickly, then it would be rather boon for promoters rather than boon for creditors. Thank you.
Mr. Ritesh Kaudia.
Yeah, I agree with.
Just concluding, 1 minute.
Yeah, and basically IBC provides a platform and it has provided a paradigm reform for the stakeholders, and all the stakeholders will have to work towards achieving the policy objectives, be it COC, be it RP, be it creditors, be it debtors. So everyone has to put in some discipline, and the code provides sufficient checks and balances at every level. So we are hopeful that things will be brighter as we move ahead.
Over to Uma Nair.
Thank you, sir. Thank you very much. It was a see feedbacks coming up from the participant through email as well as in the chat. So I could see the few I would like to tell here, like they have told that they should see that the way the speakers have discussed on the mega issues. Okay, and they felt that it was a very wonderful and a knowledgeable session. So I would like to thank all the dignitaries for the day. for giving your valuable time on Saturday and coming over here and making this program very successful. So thank you very much, sir. I would like to thank a special thank to Tatva Legal, AAA Insolvency and KSR and Co for supporting this program. Thank you very much. I also would like to thank Karur Vaishya Bank, being the banking partner for this program. And I would like to thank our supporting partner ICSI for supporting this event, and also our office bearers TCI and Renew Power. So thank you very much. Thank you for all your time, and it was a wonderful session. Thank you, sir.
Thank
Thank
you
you
all
very
for
much.
me also.
Thank you
So
all.
nice
Thank
to
you.
us.
Thank you all. Thank you all,
Thank you.
and thanks to Asacham.
Thank you very much.
Thank you.
Thank you,
Thank you.
sir. Have a nice day.
Thank you.